Lynn Chair from Perth Commercial Property with this week's commercial news update. What I'm going to cover today is the preparation of commercial leases, the inclusion of a redevelopment clause in commercial leases and what you need to consider as a lessee, and also the Improper Dealings Caveat Form C4, which Landgate has created in order to assist in protecting you against property fraud. Okay, let's start with the preparation of commercial lease agreements. Let's assume we've located a high quality tenant that wants to lease your property. The next decision you have to make is in what form the lease agreements will be prepared. Now I can tell you that there isn't a standard commercial property lease form. REWA does produce a commercial lease agreement for use by REWA members. Now Perth Commercial Property is a REWA member. However, we advise that your commercial lease documents are prepared according to the individual characteristics of each lease. Therefore, we strongly advise that you engage the services of an experienced commercial property solicitor in preparing your lease documents. The next question is that of cost. Who pays? Well, I can tell you that there isn't any legislation that governs the preparation of a commercial lease unless, of course, that lease is a retail lease. So let's assume that your lease is a non-retail lease. In this instance, you're free to negotiate who pays or who carries the cost of the preparation of the lease documents. In Western Australia, it's very common practice for these costs to be on charge to the tenant. So the owner selects the solicitor to use in preparing the lease documents. However, it is the tenant, the incoming tenant, who covers this cost. However, if the lease is to be for a retail property, the Retail Shops Act actually specifically outlines that these costs cannot be on charge to the tenant. Okay, next I'm going to cover what is a redevelopment clause in relation to a commercial property lease. Now, a redevelopment clause usually entitles the owner to terminate a lease agreement before the end of the lease term, and this is in order to undertake major renovations or to redevelop the property. Now, before agreeing to the inclusion of a redevelopment clause in your commercial lease, you might want to consider the following. How much notice must you be provided before a redevelopment clause is invoked? What this will mean to your business in terms of relocation or the loss of potential goodwill from your current establishment? And lastly, what will be the effects of any investment that you've spent on fit out? Do you want to spend as much on fit out if there's a potential that you can be asked to leave before the end of your lease term? And finally, we're going to cover off on the Improper Dealings Caveat Form C4, designed to protect or assist in protecting you against property fraud. Now, in response to recent property fraudulent cases in Western Australia, Landgate is now offering the service whereby you can lodge an Improper Dealings Caveat. The lodgement of the caveat will then prevent any instruments or documents which ordinarily need to be signed by the owner from being registered, such as the transfer of land, registration of mortgages or leases. Now, in order to lift a caveat, all owners must in fact present themselves to the Landgate office in Midland and as a minimum have 100 points of ID check. It's worth noting also that a power of attorney cannot simply lift the caveat. Now, every time you lodge or release the caveat, the current cost is $160. Well, that's it for this week's commercial property update. Be sure to give me a call or send me an email should you have any questions.